Okay, I'm Eric Schnapper. I went to law school at Yale between 1965 and 1968. Then I clerked for the California Supreme Court. After that, I worked with a couple of brief pauses for the NAACP Legal Defense Fund in New York City for 25 years. There was a period or two in there when I worked in some campaigns, and I worked for a year as the administrative assistant to Congressman Tom Lantos of California. When I was at the Legal Defense Fund, I ended up spending the vast majority of my time doing appellate litigation in a variety of areas, particularly voting rights and employment discrimination. And over time, that really became my niche at the Legal Defense Fund. More than any particular subject matter, it was doing appellate litigation. And I had the good fortune, as a result of a variety of circumstances, to be able to work on a substantial portion of the Legal Defense Fund Supreme Court work over that period of time. Also, starting in 1979, I taught part-time at Columbia, half-time for a while. Then after 1995, I moved to Seattle, where I've been teaching at the University of Washington School of Law. And most of my non-teaching time I've spent doing appellate litigation, almost entirely Supreme Court litigation, although occasionally something in the Courts of Appeals. No, no, I absolutely not. I, like most people who got out of law school, I really didn't have a clear picture of what I wanted to do. I'd spent a summer at a big firm, and I found the people quite nice, and the view was terrific. But it wasn't what I wanted to do. And I think, like a lot of people right out of law school, where I ended up was affected by where people I'd known at law school had gone. So I knew someone from law school who had gone to the NAACP Legal Defense Fund, and he suggested I apply there. I did, and I got the job, I think, partially because the judge I had worked for, was a justice on the state Supreme Court, was a big advocate of, a big opponent of capital punishment, and he'd written a very famous opinion. So I was hired at the Legal Defense Fund, never worked on a capital punishment case. But there's a fair amount of happenstance in how I got there. But those were real boom years for public interest law. The public interest firms were new and growing. There were far more of those jobs in 1968 or 69 than there are today. I think I was dealing with the issues that the Legal Defense Fund was involved in. So voting and employment were a large part of our docket. The other major part was desegregation, which I, for any number of reasons, just didn't happen to get involved in. I didn't have a long history of involvement with the civil rights movement before then. I'd actually been at the March on Washington, but aside from that, had no particular involvement with the movement until I ended up at the Legal Defense Fund. But I think the subject matter of what I got involved in was dictated by the work of the office. Litigation and teaching kind of interact in a couple of different ways. First of all, I think teaching forces you to go read cases for reasons that have nothing to do with a lawsuit that you're involved in, just to master a field. And so it's given me an understanding of potentially important areas of the law which I would not have known about if I had just gotten into a particular case. And there have been any number of cases where that's really been terribly important, where an argument that was a winning argument would never have occurred to me but for the fact that I had taught something and seen a particular line of decisions. Conversely, in some, a couple of times, at least a quarter, something I'm teaching will overlap with a case I worked on. And so I'm able to give the students a somewhat different perspective on what went on in that case and what it means. I try not to salt classes with too many war stories, but I do some. I think it's an interesting part of law school for students. Most people who teach law schools haven't never really litigated. So I think it adds to the teaching, but also strengthens what I'm able to do as a litigator. Absolutely. I have a very particular case in mind. There's a recurring problem in employment law. It's actually come up long before it came up in a Title VII case. It came up under the National Labor Relations Act about employers who, if they get angry at one worker because he or she has done something protected by the law, they retaliate against somebody else, typically a family member. And this, you can find these cases going back to the 30s, once the National Labor Relations Act was adopted. Brothers and sisters, fathers, daughters would get fired because of what a particular worker did. This had come up repeatedly in the context of Title VII, which bans employment discrimination. One worker would complain about discrimination, and the employer, in a sort of an exercise of low cunning, would then retaliate against a relative. And all those cases have been lost. The plaintiffs had never been able to figure out how to challenge that, because the person who had been fired, typically, and sued hadn't engaged in the protected activity. One worker would complain about discrimination. That's protected. You can't retaliate against them. The company would retaliate against the brother or the sister, or in my case, the fiance. So in my particular case, a woman complained about gender discrimination, and they fired her fiance. And this was a problem no one had been able to solve. And there wasn't really even a circuit split about it because every case had been lost. But I happened to get into it in a case in which there had been an en-banc decision with many different opinions, which was the sort of thing that would get the court's attention even if we didn't have a circuit split. I was aware of a line of cases that had talked about the problem of one person being injured by a violation of somebody else's rights. And the example we typically use in class is if there's an illegal search and seizure of a drug dealer, the car dealer who was going to sell a big expensive car to the drug dealer then loses the sale. They've lost money, but it wasn't a violation of their rights. But that concept that a violation of one person's rights could injure someone else was something I had seen teaching that. So I looked at this situation, and it occurred to me that one way to describe it was that they were violating the rights of the woman who complained by retaliating against her husband or fiance. So the fiance was injured, and the claim was by a violation of somebody else's rights. Now, the law in that area is usually, if you're injured by a violation of someone else's rights, you can't sue. But sometimes you can. It depends on the way a statute is written. So instead of arguing that this violated the man's rights, we said it violated the woman's rights, that he was injured, and because of the way the statute was written, he could sue for an injury caused by a violation of her rights. Once you frame it that way, it was a 9-0 win. Never would occur to me, it never occurred to anybody else. But because I'd seen that line of cases, the concept of one person being injured by a violation of somebody else's rights, just jumped out at me from the fact pattern, and it was all because of what I taught. Yeah, the concept wasn't one that was unique to the other kind of cases. It was what I described. You could have a situation where one person's injured by a violation of somebody else's rights. Usually the injured person can't sue, but sometimes they can. It depends on the way the statute's written. As soon as you say that, it fits this case. I don't think being an advocate and being a teacher for the kind of work that I do has posed a problem. I try to teach the classes that I teach very much from a litigator's point of view. So we work to understand what's been decided and then spend some time talking about how you would use that in the real world. If you had another kind of case, how would you argue about it? And I work very hard to look at it from both plaintiff and defendant sides, because I think it's better preparation for the students, because I think to be a good lawyer, you have to understand how the other side would use an argument, how they develop reasoning. So I'll say, if you were the employer and the facts were X, how would you argue for your side given this case? And so the way I teach, I think, is not typical of academics. I do it very much from a litigator's point of view. But my sense about this is, to be a good litigator, you have to understand how either side would look at it, and I try to work very hard to to do that. I don't think anyone's wondering who I would be representing in those lawsuits, but I work very hard to look at both sides. Certainly. The vast majority of the Supreme Court litigation I do are employment cases where I represent the workers. I'd say within that group, the large majority are employment discrimination or retaliation cases, including sexual harassment cases. Most often under Title VII or the Age Discrimination in Employment Act, or perhaps the Americans with Disabilities Act. I've done a couple of Fair Labor Standards Act cases. That's the statute that requires that people be paid overtime as well as the minimum wage. And I've occasionally gotten into other areas, but that's been the bulk of what I've done. Well, I get into cases a couple of kinds of ways. Sometimes people just call me up. Sometimes people I knew, sometimes people I hadn't worked with before. And those will tend to be employment cases because there's a bar of lawyers who do employment cases. I know a large number of them. So they would typically call me about an employment case. It's what they do and what they know I do. Occasionally, I'll get asked to help with a case that's not an employment case. As often as not, it's from a law firm that I worked with in an employment case, or at least know of from employment law. And every case is a little bit different in terms of how I get into it, but the cases I tend to look through when I'm trying to keep track of what's going on in the lower court would be employment cases ordinarily. That's just what I follow. There's a fair amount of specialization in all of this. If I read an excess force case, I would not typically understand how important an issue would be. If the opinion said there was a circuit conflict, I would understand that. Some of them do. But as often as not, an important case is not going to include a sentence saying we disagree with 3 other circuits and tip everybody off that there's something going on here. I will, more than I think most people who work in this area, I'll take on a case which is a bit of a long shot, where there's not really a conflict or it's not much of one, because it's particularly important in employment law. And frankly, I can afford to do that. If you do this for a living, as some people do, you just can't afford to do that sort of thing. And as an exercise for students, if you're running a clinic, it's better to take on a case which has a chance, which is a higher chance of being granted. You know, I'm in a position to be able to take on some cert petitions where the odds are not really terribly good. But when I go looking for cases, it will more often be employment cases. What comes in the door can sometimes be other things.